In this segment of our conversation with Justice Madlanga of the Constitutional Court, we look at the process of judging, specifically the factors that influence judges in the judging process. For example, their subconscious biases and prejudices. To help us set a scene for that conversation, I have a copy of a journal published by the South African Judicial Education Journal. It's volume 1, issue 1 of 2018. It's an article written by Justice Madlanga, and it starts at page 51 and goes on to page 53 of this book. So to set a scene, let's just see what he has to say about the subject. He says, a judge's makeup, outlook on life, and indeed entire being follow him or her. Judges cannot be expected to entirely jettison all of their biases and perspectives about the world upon stepping into their judicial roles, because meeting such a standard would be a superhuman feat. That is the focus of our conversation. I would qualify their biases by referring to subconscious biases. Some may view this proposition with suspicion. But what are the alternatives? No individual can function other than in accordance with who they truly are. Let me be practical. Imagine a man of extremely limited means. He shares a small apartment with his family, his wife, his mother, his sister, and his 2 small children, one of whom suffers from cystic fibrosis. His wife stopped working because of her pregnancy and is now focused on caring for their sick child. The man was fired from his job as an insurance agent when the insurance premiums he collected were stolen from his home. When he was unable to make up the sum, his former employer filed a claim against him. Although he has since diligently looked for work, the bad reference from his former employer has made it impossible for him to find another steady job. His family survives entirely on public assistance. His only assets are the clothes he wears, some essential household goods, and a couch in storage. This man desperately seeks to file for bankruptcy, including discharge of the debt he owes to his former employer, so that he and his family can make a new start in life. Due to his poverty, he cannot afford the filing fee. He cannot pay it as a lump sum. He cannot pay it in installments. He cannot borrow money to pay it. He is utterly without options. This is not a hypothetical set of facts. This is what was before the U.S. Supreme Court in United States versus Grass. At issue was whether insistence on payment of the filing fee in Mr. Kras's circumstances was consistent with the due process and equal protection guarantees of the Fifth Amendment. The court said it was. Writing for the majority, Justice Harry Blackman held that the filing fee amounted to, and I quote, a sum less than the payments Mr. Kras makes on his couch of negligible value in storage, and less than the price of a movie, and a little more than the cost of a pack or 2 of cigarettes. If, as Mr. Kras alleges in his affidavit, a discharge in bankruptcy will afford him the new start that he so desires, and his former employer then no longer will charge him with fraud and give him bad references, and if he really needs and desires this discharge, this much available revenue should be within his able-bodied reach. In a separate dissenting judgment, Justice Thurgood Marshall remarked scathingly as follows: no one who has had close contact with poor people can fail to understand how close to the margin of survival many of them are. A sudden illness, for example, may destroy whatever savings they may have accumulated, and by eliminating a sense of security may destroy the incentive to save in the future. A pack or 2 of cigarettes may be for them not a routine purchase by luxury, but a luxury indulged in only rarely. The desperately poor almost never go to see a movie, which the majority seems to believe is an almost weekly activity. They have more important things to do with what little money they have, like attempting to provide some comforts for a gravely ill child, as Mr. Kras must do. And here comes the kicker. It is perfectly proper for judges to disagree about what the Constitution requires. But it is disgraceful for an interpretation of the Constitution to be premised upon unfounded assumptions about how people live. Surely, Justice Marshall's analysis must have been influenced by his background, whether it be growing up as an African American and witnessing poverty in close proximity, or possibly in his many years of litigating cases on behalf of the Legal Defense and Education Fund of the NAACP. His clients were African American, who then, as now, were among the poorest and most systemically disadvantaged sections of the United States population. His intimate knowledge of the challenges facing poor people and his anger at the majority's unfounded assumptions about their lives shines through every word of his dissent. Now, that is the excerpt upon which our conversation with Justice Madlanga is premised. Welcome to Anchored in Law, the unembedded take on law. We are in conversation with Justice Madlanga of the Constitutional Court of South Africa. Justice Madlanga, thank you for talking to us at Anchored in Law.
Thank you.
The judicial diversity. I think some 3 years ago you gave a lecture at the University of Notre Dame in the United States in which you talked about, judges judging according to subconscious biases and prejudices. I think if I remember correctly, one of the things you say in that lecture is that it would be to expect a superhuman feat, I think are the words you used, to expect a judge to disabuse himself or herself of their subconscious biases and prejudices. Now, the first question I wish to pose in this regard is, when we talk about judicial diversity, I take it you're talking about, are you talking about diversity in the sense meant in Section 174(2), in other words, of the Constitution, in other words, that the judiciary reflect as far as possible the gender and race demographics of the country?
That for me is a starting point, and as you would have seen in the published version of the address you've referred to,
yes.
I go beyond that.
And,
yes. I say, for me, in order for everybody to recognize the judiciary as his or his, it must even reflect, or its composition must even reflect other categories of the general population. I refer, for example, to, I itemize a few things.
Yes.
I even include, for example, let us have lesbians.
Yes.
Let us have gay people on there. And I think I gave a few other examples.
Yes.
What the others are.
Yes. Yes. And so let's just test how far one can stretch that piece of string. Take, for example, a judge who has had an experience, a horrible experience, say about rape, maybe not necessarily personally on her person, but a close member of the family has been subjected to that horrific crime called rape. And the perpetrator of the crime got away with it on some technicality, and that the person who at the time was not a judge believes that the legal system failed him or her in letting the perpetrator of crime get away, and started blaming the criminal justice system. Fast forward 10, 15 years after the event, the person practices as a lawyer and then becomes a judge. One of the first cases she is allocated is a rape case. Now, a person who harbors this enmity against people who perpetrators of rape. Remember, the person is still an accused, right? The enmity that this person harbors against the accused, is it reasonable to expect that a judge with that kind of experience from the past would be able to disabuse herself of her own subconscious bias against a rape perpetrator in determining a rape case?
I think it's right thinking people we should proceed from the premise that all judges take an oath of office, which is to administer justice without fear, favor, or prejudice. And if we have no reason, and by reason I mean cogent reason, to believe that a judge will not administer justice in accordance with that oath, I think we have no reason to have those fears. If a judge were to allow her or himself to be influenced by such experiences, they would then not be true to their oath of office. And the operative word here is allow, because there you are actually consciously letting these personal experiences to dictate the outcomes that you come to in your decision making. That is totally not acceptable, and that indeed is not what I am suggesting.
Yes, of course. But then we will never know whether or not a judge allows his or her personal experiences to color his or her judgment in a case until he or she confesses that to be such. Because
or is caught out one way.
Or is caught out. Because I imagine one can reach a particular outcome using the law, but navigating one's way around the law in order to make the law fit into one's own inarticulate premise. Now, one can never discover that such a judge was indeed steeped more into her personal experience than in the application of the law. So I guess what I'm saying is, isn't it possible for a sitting judge to mask his or her inarticulate premise and personal experience and subconscious bias in the law?
Judges being human beings, I would never sit here and say it is inconceivable that could happen. I would never say that. But again, as I said earlier, a judge who does that is not being true to the oath of office that they have taken. If, as you say, she or he is clever enough to cover it up sufficiently, then unfortunately, all I can say is tough luck for us, tough luck for justice. But that would not be acting with integrity. That would not be acting in accordance with the oath of office.
Yes. And so you say in your published piece, Justice Madlanga, that, and I repeat this, you said it would be to expect a superhuman feat if we were to expect that a judge would disabuse himself of a subconscious bias. So in other words, you're saying it is appropriate that a judge carries his or her subconscious bias and prejudices onto the bench. You don't become something else, or you don't lose who you are just simply by being elevated to the bench.
Just putting on those robes does not change Mbuyiseli Madlanga.
Yes.
That boy who grew up at Njijini in Mount Frere, I remain just that.
That boy who did...
An older version of that boy, of course.
Yes.
Yeah.
Now...
And fortunately, at least on this, this is not my own thought or a thought that I've come up with.
Yes.
It was said in 1921 by Justice Cardozo
Yes.
of the United States of America.
Yes.
But very fortunately, it has been adopted by our own constitutional court in the Sarfu matter in so
Yes.
many ways, and they quote Justice Cardozo in so many ways.
Yes, and I was wondering in my own mind how one reconciles that with what the Supreme Court of Appeal said. I think it was in 2011,
Yeah.
in the case of Makiki versus S. Makiki was appealing to the Supreme Court of Appeal. And this is what Justice Ponan had to say. He said, predictable outcomes, not outcomes based on the whim of an individual judicial officer, is foundational to the rule of law, which lies at the heart of our constitutional order. Now, if one were to accept that a judge cannot disabuse himself of his subconscious biases, and therefore he must be accepted on the bench with his warts and all, and subconscious prejudices, isn't that in effect allowing for the whim of an individual judicial officer to trump the predictability of outcomes, which lies at the heart of the rule of law and the constitutional principle?
I doubt that Justice Ponan, in what you have quoted, is saying anything different to what I have said, what the Constitutional Court has said, what Justice Cardozo has said. I think what he's referring to there is more whim in the context of, sudden change of mind, sudden desire, that sort of whim. That too, and I think somewhere in my address, I do make a similar point. And unfortunately, in this sort of context, I can't even whip or flip through the pages and read to you. I actually do make a point similar to what Justice Ponan is saying.
Okay.
So the two actually do accord.
Okay.
But he's not suggesting that, and in not following a whim in the manner in which I understand it, he will suddenly not be Justice Ponan. I don't understand him to be saying that.
Okay, let's take it further in the next segment, Justice. Thank you.
Thank you very much.